नमस्कार, प्रणाम, जय श्री राम। दर्शकों का स्वागत है इस YouTube चैनल पे। आज से मैं एक नई सीरीज शुरू कर रहा हूँ, जॉइंट पार्लियामेंट्री कमेटी ऑन वक्फ अमेंडमेंट बिल 2024। यह रिपोर्ट JPC ने 30 जनवरी 2025 को लोकसभा लोकसभा के स्पीकर को सबमिट किया और इसके ऊपर अभी लोकसभा राज्य सभा में चर्चा बाकी है। मैंने सोचा कम से कम ये चर्चा शुरू होने के पहले आप सबसे इस बारे में साझा करूं कि इस रिपोर्ट में क्या क्या दिया हुआ है। चूँकि यह रिपोर्ट इंग्लिश में है तो ये एपिसोड्स आने वाली सीरीज़ में इंग्लिश में बनेंगे। इसका हिंदी अनुवाद भी मैं बहुत जल्द बना रहा हूं, जो आपको समय आने पर आपको प्रकाशित करेंगे। तो शुरू करते हैं। सो लेट्स बिगिन। Lok Sabha report on the Joint Committee on Waqf Amendment Bill 2024, 18th Lok Sabha. This was presented to the Honorable Speaker on 30th Jan 2025. So the report here is, as you can see, the table of contents, Chapter 1 Introduction, most important clause by clause examination of the Waqf Amendment Bill 2024. So it starts from page 14 and goes up to a whopping page 404. Chapter 3 is other related issues and consolidated observations. Recommendations of the committee are from page number 409 to 428. Definitely for such a voluminous report you need appendices. So all those appendices are here. Motion in Lok Sabha for reference of the bill to joint committee. Motion in Rajya Sabha for reference of bill to joint committee, extension, minutes of various sittings, notes, minutes of dissent received, and various other annexures. So I'm slightly changing the presentation of this report, wherein I would be going to the consolidated observation recommendations of the committee first and then going into the background of it, how this consolidated observations or recommendations could finally take shape through a huge and long consultation process involving these 400 odd pages. So let me take you straight to page number 409. So as you can see here, it's a long list of recommendation. So we begin from the consolidated recommendations, clause by clause. Many of the users may not appreciate what exactly these recommendations are till the time they don't revisit or do a first reading of various clauses mentioned here. But just for information purpose, at least you will get a feel of what recommendations have gone forth, how much the Waqf Amendment Bill has been really amended to the extent that it has diluted the earlier one-sided and stringent clauses of Waqf Act 1995 various amendments, the most draconian being 2013 amendment, which was done just few days before the new government of Modi 1.0 regime could take office. So let's proceed. Clause 1. No amendment is proposed in the said clause dealing with the short title and commencement of proposed legislation. Clause 2. The committee, after thorough deliberation on the proposal and considering views of experts, stakeholders and Ministry of Minority Affairs, concurs with the change in the nomenclature of the Waqf Act to the name Unified Waqf Management, Empowerment, Efficiency and Development Act. I think you must have heard the acronym UMMEED. So the W is silent, but if you see UMEED, UMMEED Act. So we can also call this amendment as the UMMEED Act. The updated name effectively reflects the evolving priorities and challenges in Waqf management, emphasizing unified administration, inclusivity, operational efficiency, and proactive development. This nomenclature encapsulates the amendment bill's vision, addressing systemic gaps while promoting modern, transparent, and accountable governance in the Waqf management. The committee recommends its adoption as an essential step towards aligning Waqf management with contemporary needs and practices. Next, Clause 3. The committee, after thorough deliberation on the amendments proposed to existing definitions and on the inclusions of new definitions proposed in the clause under examination, and after taking into consideration the views and suggestions of various stakeholders and the justification furnished by the nodal ministry, are of the view that proposed definitions of collector, government organizations, government property, portal and database, and amendments to the definition of muttawali and waqf are in tandem with the other amendments proposed in the bill, with the intention to streamline the waqf property management, reduction in number of litigations, this is very important, expanding the scope of beneficiaries of waqf, etc. The committee have decided to accept the amendments proposed except for amendment proposed wide clause 3(9). So as we go into the detail and when we go back and study the clause 3(9) needs to be looked into. Regarding the proposed amendment stipulating that only a person practicing Islam for at least 5 years will be permitted to dedicate any movable or immovable property as waqf, the committee proposes the following amendment to clause 3(9)(a). In the opening portion, for the words any person of any movable or immovable property, the words any person showing or demonstrating that he/she is practicing Islam for at least 5 years of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of this property. To simplify the interpretation, should have ownership of that property, that means all the papers should be in order and there is no contrivance, in the sense there is no challenging litigation or an order in the court or any of the collectorate's office. Regarding the amendments proposed in the definition of the waqf, the committee have observed that the proposed omission of waqf by user through clause 3(9)(b) of the amending bill have created apprehensions among various stakeholders and the Muslim community at large regarding the status of the existing waqf by user, which largely includes properties used for religious purpose. Just to make all my users aware, waqf by user has been the most draconian clause in this Waqf Act and various amendments, and which has been brought to the notice of millions of people by various experts. The most prominent, according to me, being Dr. Anand Ranganathan, who is very vocal on this topic, and which is being equally contested in various courts by Vishnu Jain ji and Hari Shankar Jain ji. They are challenging waqf by user clause, and that is where these recommendations are taking shape. The committee, in order to evade such apprehensions, propose that a proviso clearly specifying that the omission of waqf by user from the definition of the waqf will apply prospectively. That is, the cases of existing waqf properties already registered as waqf by user will not be reopened and will remain as waqf properties even if they do not have a waqf deed. Now, this, according to me, has been severely diluted. The reasons well known. There have been a lot of protest within and outside the proceedings of JPC, and this recommendation getting diluted will create the same status quo situation. Only ray of hope is prospectively, that is, from the day the committee's recommendation gets implemented through a government notification called as GR, there would not be any waqf by user category involved. Going further, this would, however, be subject to the condition that the property wholly or in part must not be involved in a dispute or be a government property. So here, committee has safeguarded government land, government property, and for private sector or individuals. If at all there is a waqf by user category and it is involved in a dispute, then this will not be omitted. they will have to follow the course of law and get the dispute resolved, and naturally government property will definitely be transferred to the government. Accordingly, the following amendment to clause 3(9) is proposed. The following proviso shall be inserted, namely, provided that the existing Waqf by user property is registered on or before the commencement of Waqf Amendment Act 2024 as Waqf by user will remain as Waqf properties except that the property wholly or in part is in dispute or is a government property. So safeguards are kept. Prospective effect is given and not retrospective effect. We move further. Further, as regards the amendments to the definition of Waqf Alal Aulad, wherein through proposed amendments the scope of benefit will be further expanded for maintenance of widow, divorced woman and orphan in such a manner as may be prescribed by the central government, the committee, after considering various submissions, recommend that the intention of the Waqif should be taken into account while deciding the beneficiaries of a Waqf. Accordingly, following amendment to clause 3(9)(c) is proposed. In subclause 4, after the word orphan, the words "if Waqif so intends" shall be inserted. Clause 4. The committee, after thorough deliberation on the amendments proposed to defining certain conditions of creating a Waqf, except the amendment defining the condition of making a Waqf that only a lawful owner of a property can dedicate it as Waqf is acceptable. So, very important, only lawful owner of the property. Anybody just taking their claim on a land or a piece of land parcel as Waqf will not apply. As regards the conditions stated for creation of Waqf Alal Aulad, the committee have proposed further amendments. Accordingly, following amendment is recommended in clause 3(a)(2). After the word Waqif, the words "or any other rights of persons with lawful claims" shall be inserted. So, all fake claims of just saying that this land parcel or this property belongs to me, or it is a Waqf property, or it is a Waqif, will no longer be applicable. As regards the proposed new section 3(b)(1) and 2 regarding filing of details of every registered Waqf property on the portal and database within 6 months, and the details that needs to be filed, the committee, while accepting list of details to be filed on the portal as given in clause 3(b)(2), are of the opinion that a window should be kept open for filing of details of the registered Waqf property even after the lapse of the period of 6 months in genuine cases by making the following amendments to proposed section 3(b)(1) under clause 4. Provided that tribunal may, on an application made to it by the Muttawali, extend the period of 6 months under this section for such period as it may consider appropriate if he satisfies the tribunal that he has sufficient cause for not filing the details of the Waqf on the portal within such period. On the new section 3(c)(1) dealing with wrongful declaration of Waqf, the committee accepts the recommendation that any government property identified as or declared as Waqf property shall not be deemed to be a Waqf property. So, no deemed acceptance allowed. Nonetheless, the committee have received strong objection on the proposal of delegating the power of determining whether a property is a Waqf property or government property to the collector. So, users must remember, few months ago there was a lot of hue and cry on this particular provisioning where collectors were given powers. All opponents to this amendment were blaming this as draconian powers given to the hand of the collector. The committee feel that in such a scenario, the decision of appointing an official to conduct an inquiry in cases of wrongful claims on government property by Waqf board should be left to the state government. The committee therefore recommend the following amendments to the proposed section 3(c), 2, 3 and 4. In clause 4, in the newly proposed section 3(c)(2), after the words government property, for the words the same shall be referred to the collector having jurisdiction, who shall make such inquiry as he deems fit. the word state government may by notification designate an officer above the rank of collector, hereinafter called the designated officer, who shall conduct an enquiry as per law, shall be substituted. In clause 4 in proviso to section 3C2, the word collector be substituted with the word designated officer. In clause 4 in proposed section 3C3, the word collector to be substituted with word designated officer. And similarly, in clause 4 section 3C4, the word collector be substituted with the word designated officer. Clause 5, the committee, after careful and comprehensive deliberation on the proposals outlined in the clause under examination, including an evaluation of the views and suggestions provided by stakeholders and the justification presented by the Ministry of Minority Affairs, acknowledged the merit in the proposed amendments. These amendments aim to transfer the responsibilities previously assigned to the Survey Commissioner under the Waqf Act 1995, such as overseeing the survey of properties, to the collector. Under the proposed framework, the collector, instead of the survey commissioner, will conduct the survey in accordance with the revenue laws of the respective state. Now, this is a very important amendment, and submit the report to the state government. The committee find that this adjustment will streamline the survey process and better align it with the existing administrative framework. Significantly, the function of the collector for survey and registration will integrate professional expertise available with the collector's office and increase authenticity of the land transactions. Given that collectors are already deeply involved in matters relating to land and property within their jurisdiction, this change is expected to exhibit objectivity, enhance efficiency, reduce redundancies, and ensure a more integrated approach to the management of Waqf properties. Recognizing these advantages, the committee endorses the proposed amendment in the clause as a pragmatic and administratively sound measure. The committee, clause 6 amendment, the committee, after comprehensive deliberation on the proposals outlined in the clause under examination, acknowledge the merit in the proposed amendments, wherein detailed procedure with defined timeline for publication of list of Waqf in the official gazette, uploading of list on the portal, and mutation in land records has been brought out. These amendments ensure transparency and accountability in the management of Waqf properties, hence accepted by the committee, except for amendment proposed in subsection 2 of section 5 through clause 6C, which proposes insertion of new subsection 2A. It is recommended that the time period proposed for uploading the notified list of Waqf on the portal and database after its publication in the official gazette by the state government may be revised from 15 days to 90 days. Accordingly, the following amendment is recommended in clause 6C. The state government shall upload a notified list of Waqf on the portal and database within 90 days from the date of its publication in the official gazette under subsection 2. Clause number 7. The committee support the extension of the time period for instituting a suit in the tribunal on any dispute regarding the nature of Waqf from 1 year to 2 years from the date of publication of the list of Waqf, as the amendment ensures fair access to justice. However, the committee are of the opinion that there can be delays in filing suits in such cases due to various reasons, and thus recommend that the tribunal shall have power to condone delays beyond the proposed 2-year period for entertaining applications regarding disputes over Waqf properties on a case-to-case basis. Accordingly, following amendment to clause 7A4 is proposed. For the second proviso, the following provisos shall be substituted, namely, provided further that an application may be entertained by the tribunal after the period of 2 years specified in the first proviso, if the applicant satisfies the tribunal that he had sufficient cause for not making the application within such period. The other proposed amendment in clause 7 are merely consequential, therefore the committee accepts them as it is. Clause 8, the committee agree with the proposed amendment to proviso A of section 7(1) of the Waqf Act 1995, which extends the time period for approaching the tribunal from 1 year to 2 years. This extension ensures that aggrieved parties are provided with a fair and reasonable opportunity to present their cases. the provision allowing the tribunal to accept late applications upon the presentation of valid reason further ensures that deserving cases are not dismissed merely due to time limitation. Thus, in view of the submissions made by Minister of Minority Affairs and the fact that the other proposed amendments are merely consequential, the committee accepts the amendments proposed in Section 7 of the Act as it is. Viewers, I will take a pause here because the list of recommendations are long and these are quite exhaustive and in detail. So, in the next episode, I will be running you through the balance recommendations from clause 9 onwards. Till then, stay tuned, stay connected. If you liked my video, please press the like button, subscribe to my channel, and also share this in your network. Do not forget to press the bell icon so that you continue to receive further updates and videos on my YouTube channel. Till then, thank you, Dhanyavad, Namaskar, Jai Shri Ram.